Have you ever complained about something and the person in charge just kept saying, noted, noted, moving on?
Oh, constantly. I once disputed a charge on my phone bill, and the rep talked over me 4 times before I gave up.
And then imagine someone later tells you that because you stopped talking, you must have agreed with the charge all along.
That's not fair. I stopped talking because they wouldn't let me finish.
Exactly. That's basically the fight at the center of today's case, Pitchford versus Cain, a death penalty case before the Supreme Court. The Supreme Court hears oral arguments on Tuesday, March 31st. Welcome back to the High Court Report. Today, a death row case where an African-American man in Mississippi argues the prosecutor handpicked a nearly all-white jury through racial discrimination, and where the court still won't let him prove it. Before digging in, let me remind you to please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for a nearly daily rundown, and follow on YouTube to see shorts. Just search the High Court Report. All right, here's what you need to know.
The Supreme Court must answer whether, under a federal law called AEDPA, the Mississippi Supreme Court unreasonably determined that Terry Pitchford waived his right to rebut the prosecutor's race-neutral explanations for striking 4 black jurors.
Break that down.
There's a landmark 1986 Supreme Court case called Batson versus Kentucky, the foundational case on racial discrimination in jury selection, that says prosecutors cannot kick jurors off a panel because of their race. Proving racial intent requires a 3-step process. Step 1. The defendant shows a pattern that looks discriminatory. Step 2. The prosecution gives a race-neutral explanation for each strike. Step 3, the critical one, the defendant gets to argue those explanations are a cover story, a pretext.
So the defendant gets to punch back.
Exactly. The question here, did Pitchford ever get that chance? And did Mississippi's courts handle it fairly?
And AEDPA?
The Anti-Terrorism and Effective Death Penalty Act, Congress passed it in 1996. It tells federal courts, hands off state criminal convictions unless the state court made a ruling no reasonable judge could ever reach. Very high bar.
So federal courts can't step in unless Mississippi got it really, really wrong. That's the fight. And the facts here, kind of insane.
In what way?
Same prosecutor, same county, same judge, 2 years apart, 2 separate defendants. Both trials ended with 1 black juror on the panel. Let's get into it. November 7th, 2004, Terry Pitchford and Eric Bullins robbed the Crossroads grocery store in Grenada County, Mississippi. Bullins shoots and kills store owner Reuben Britt. Pitchford shoots Britt with a separate gun. Both men steal money and a cash register. Police arrest Pitchford shortly after. He confesses to police and to 2 fellow inmates.
The underlying crime isn't really what this case turns on. The fight lives entirely in jury selection. Grenada County counted roughly 40% black residents in 2006. About 40 of 126 potential jurors came in as black. After cause strikes removed jurors for specific disqualifying reasons, 5 black potential jurors remained eligible. Prosecutor Doug Evans then exercised his peremptory strikes, the kind that let lawyers remove jurors without giving any reason at all. And before he struck a single person, Evans marked up his juror list with the letters W and B next to each potential juror's name.
He wrote down their races in writing.
Evans struck 4 of the 5 eligible black jurors, 80% of them, and only 8.3% of the eligible white jurors, 3 out of 36. 3 of those 4 black jurors never received a single question from Evans during voir dire, the courtroom questioning process. He struck them without ever speaking to them. The jury that convicted Pitchford and sentenced him to death contained 1 black juror out of 14.
Defense attorney Allison Steiner raised a Batson challenge, objecting on the record that the strikes reflected racial discrimination. The trial court shut her down 3 times. First, during jury selection, Steiner reminded the court that Batson Step 3 required the judge to assess all relevant circumstances and determine whether the prosecution's explanations were credible. The court's response: just let the state give race-neutral reasons. Evans gave a reason for each juror. The court called each one race-neutral and moved immediately to the next strike. Steiner never got a word in.
She tried again right after the jury got seated. The court said, and this is the line everything turns on, "You have already made it in the record, so I am of the opinion it is in the record. Proceed to trial."
The court called it handled, but no one ever examined whether those race-neutral reasons were real or just cover. She raised it a third time in a motion for new trial. Denied without a hearing. On direct appeal, Pitchford laid out a full comparative juror analysis showing Evans struck black jurors for reasons that applied equally to white jurors who sat. Mississippi Supreme Court: you didn't make those arguments in the trial court. Waived.
2 rounds of state court, then federal habeas. The Fifth Circuit, the federal appeals court covering Mississippi, upheld the waiver ruling under AEDPA. Now it sits before the Supreme Court, which took it on the narrow question: did Mississippi's waiver ruling fly?
Let's turn to the oral arguments, starting with Pitchford. Pitchford's first argument goes: Mississippi made an unreasonable factual finding when it called his challenge waived. Waiver requires intentional abandonment of a known right. If you try to return a defective product and the store manager cuts you off every time, and then the store later says you never complained, that's not a waiver. That's a denial of the opportunity.
Pitchford points to Brumfield versus Cain and Wiggins versus Smith, 2 cases where the Supreme Court found state courts unreasonably ignored obvious record evidence. Here, 3 on-the-record objections sit in the transcript, plus the trial court's own words confirming the objection's existence. No fair-minded judge could call that a waiver.
Pitchford's second argument: Mississippi wrongly blocked comparative juror analysis on appeal. Evans struck Tillman because his brother had a manslaughter conviction, but accepted white jurors with relatives convicted of felonies. Evans struck Ward partly for being unmarried with a young child, but accepted 11 white jurors who shared at least one of those same characteristics. The stated reasons applied to white jurors who stayed on the panel.
2 Supreme Court cases, Miller L. versus Dretke, the 2005 case that reversed a Texas death sentence, and Snyder versus Louisiana from 2008, both involve the court conducting that comparative analysis for the first time on appeal, precisely because the defendant never got the chance below. Mississippi applied a forfeiture rule those precedents directly contradict.
Pitchford's third argument: structural error. Batson violations trigger automatic reversal, full stop. And the backdrop: Flowers versus Mississippi, the 2019 Supreme Court decision. Same prosecutor, Doug Evans. Across 6 trials of Curtis Flowers in the same county, Evans removed 41 of 42 black jurors. This court called it a relentless, determined effort to rid the jury of black individuals. That history can't disappear from the analysis of what Evans did 2 years earlier in the same courthouse.
Let's look at how Mississippi counters. First, the waiver ruling comported with clearly established federal law. The Supreme Court explicitly told states, in Batson itself, and again in Ford versus Georgia from 1991, to develop their own Batson procedures. Mississippi built a rule: raise pretext arguments before the trial court or lose them. That prevents sandbagging, holding arguments in reserve, watching whether the jury convicts, then springing new theories on appeal. Miller, L., and Snyder involved defendants who actually raised pretext arguments. They didn't forfeit them.
Their second argument goes: in post-conviction proceedings, Pitchford's own lawyers filed papers saying he failed to preserve the Batson record by failing to offer any rebuttal to the state's reasons. And Allison Steiner submitted an affidavit saying she did not do anything to raise or reserve the right to raise before the trial court any of the evidence suggestive of pretext that Pitchford later raised on appeal. Pitchford's own trial attorney said under oath she didn't try to preserve those arguments. A reasonable judge could absolutely credit the view of the record Pitchford himself once adopted.
And third, the court took a narrow question. Even a win for Pitchford gets him a do-over before Mississippi's courts, not immediate release. The Batson merits haven't been litigated yet.
So, what does this actually mean?
If Pitchford wins, the case goes back down, and for the first time, a court examines whether Evans's explanations for striking Linda Lee, Christopher Tillman, Patricia Tidwell, and Carlos Ward held any water. 19 years after the trial, Pitchford would finally get a Batson hearing.
On the other hand, if Mississippi wins, Pitchford stays on death row, and the precedent tells every future defendant, if the trial court shuts down your Batson challenge, force the issue immediately or permanently, lose the right to argue pretext.
Batson enforcement lives or dies at step 3. If states can cut off that fight and call the failure to fight a waiver, Batson turns into a procedural obstacle course where prosecutors just say magic words and move on.
All of this involving the same prosecutor this court already found engaged in extraordinary racial misconduct.
The Supreme Court hears oral arguments on Tuesday, March 31st. Listen to them here at the High Court Report. What should we listen for at oral arguments?
Watch for the justices to press hard on what Snyder actually did in that courtroom. The two sides read the trial transcript completely differently. Expect it to get pulled apart line by line.
Also, watch for the post-conviction affidavit. Steiner said under oath she didn't try to preserve those arguments. Pitchford says she tried and got blocked. The court will feel that tension. The justices may split among those who think AEDPA deference covers almost everything, and those who think some factual findings are so contradicted by the record that deference breaks down.
Bottom line, why does this case matter?
Because racial discrimination in jury selection strikes at the most basic promise of equal justice. A man sits on death row after a trial where the prosecutor flagged jurors by race in writing, struck 4 of 5 eligible black jurors, and faced no meaningful scrutiny of whether those strikes reflected legitimate judgment or calculated exclusion. And because AEDPA's deference only works if state courts actually engage with the record. Did Mississippi engage, or did it look the other way?
That's it for today's episode. Thanks for listening. Please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast, and follow on LinkedIn to get written rundowns. Talk to you soon.